just before he joins us, if possible.
Yes, Program Director. Just wanted to first make sure that the Minister is on the platform. Where's the Minister?
Let's take you back to the court case of the former Minister of Social Development. On to this now, the Minister of Justice and Correctional Services, Ronald Lamola, hosting a webinar to mark the 25th anniversary of the Constitution of South Africa being signed into law. Other speakers are still at the podium, but let's take you there live.
That fundamental human rights principle of equality, a principle that means that we embrace our diversity and demand that all be treated without any kind of discrimination. That no matter who we are, who we love, where we come from, and what we look like, we have equal opportunities to live in dignity and pursue our dreams. From the moment we are born, we have the same rights. All of us have the right to life, health, and education, to speak our minds without fear, to enjoy our days in a healthy environment. But the inequality, poverty, and unemployment inflamed by COVID-19 are pushing us backwards. The past 2 years have painfully demonstrated the intolerable cost of soaring inequalities. Around the world, and as a result, an estimated 97 million people will remain poor by the end of this year. People in vulnerable situations, such as women, youth, children, people with disabilities and migrants, and those without social protection have been the worst affected. Gender-based violence, lack of access to basic services and decent jobs are challenges and social ills that persist. The pact we have with we the people is at a crossroad. The Constitution and the international human rights treaties that South Africa has ratified offer us the way forward. We need a reinvigorated social contract that addresses deep patterns of inequality and breaks the cycle of poverty. Building back a more resilient and stable society requires a human rights-based economy that is more just, inclusive of marginalized voices, and people-orientated. Successive financial and health crises have had multidimensional impacts on millions of young people. We must ensure equal opportunities for youth to contribute to the development agenda. Vaccine inequality and injustice must also be urgently addressed. Global collaboration and solidarity will ensure fair distribution and the protection of the right to health and well-being for all. Finally, the human right to a clean, healthy, and sustainable environment for current and future generations must form the cornerstone of the new human rights-based economy. The Constitution was designed to build this nation, to unite in diversity, and ensure respect and human dignity for all. Let us do what is right. Let us work for equality. Let us stand up for human rights so that the next 25 years of this rainbow nation are better, fairer, and greener. I thank you, Program Director.
Thank you, Ms. Nako, for your kind words and a message of support, and reminding us that this journey does require lots of commitment and effort on all sides to make sure the vision is indeed realized. Unfortunately, the minister is stuck in a funeral, so we will then have to move to part 2. And then when he's available, then maybe hopefully towards the end, then we'll then have the keynote address. So in that regard, then I would then want to hand over to the Deputy Minister of Justice to talk about, to facilitate the panel discussion, and also, facilitate views from people like, he said we should call him Judge Albie, and then others in the panel. So over to you, Deputy Minister.
Thanks, Advocate Tipanyane, and good morning to everybody. Let me greet everybody, say all protocol observed. We do have a number of people on the platform. I'm told that we also may have some coverage from Newsroom Africa, who also may be covering some of this. This is then the panel discussion, and let me just by way of introduction say that today is International Human Rights Day. It's also the day 25 years ago at Sharpeville where President Mandela signed the Constitution into effect. The Constitution then took effect on the 4th of February the following year. That's about a month and a half later. So it's a sort of longish process. We had planned an event at Sharpeville, which because of the rise in COVID had to be postponed and to become a virtual event. There were other events also planned, such as Constitutional Hill Trust and the Mandela Foundation, who'd planned an event last night with President Ramaphosa at Constitution Hill. But anyway, welcome to everybody to this webinar. Just for those who don't know, the Constitution is the prime law of the land. Everything has to be consistent with it. And it requires special amendments to amend it, as opposed to ordinary legislation. It requires 2/3 of the members of the National Assembly and 2/3 of the provinces to amend it. And Chapter 1 requires 75%, which is the general principles. Our Constitution is really our identity document, our birth certificate. It defines who we are as a country, and it has a profound impact on the lives of people. Former Judge President Pius Langa spoke of the transformative nature of the Constitution in October 2006, and he said, this is a magnificent goal for a constitution, to heal the wounds of the past and to guide us to a better future. For me, this is the core idea of transformative constitutionalism that we must change. And surely that is the biggest achievement of the Constitution, that we have changed, and we've changed because of the Constitution. Since the Constitution came into effect, or really even before with the interim Constitution, which started in 1994, there's a substantial body of new laws that has emerged from all spheres of government to fulfill the constitutional mandate. There have been the creation of new democratic institutions, the repeal of discriminatory laws, laws dealing with land restitution, strengthening of land tenure, which are also being reviewed currently, the facilitation of access to housing and the provision of social assistance to those in need. Some of the laws were required in terms of the Bill of Rights and sought to address systemic and structural inequalities and prevent unfair discrimination and advance a transparent and open democratic society. There are 3 laws that the Bill of Rights requires, one on the promotion of access to information, another on the promotion of administrative justice, and lastly on the promotion of equality and prevention of unfair discrimination. And a 4th law, not mentioned, but was originally part of the Access to Information Act, the Protection of Personal Information Act. So today's webinar is the Constitution. The topic of today's webinar is the Constitution as a catalyst for the achievement of equality. This aligns with the United Nations theme for International Human Rights Day today, equality, with the sub-theme, equality as the solution to provide opportunities within and access to a fairer and more inclusive society, with the generic call to action, stand up for human rights. So we're specifically looking at the issue of equality. Obviously, equality in South Africa, with its discriminatory past, can be, we know it has different meanings for different people. But the Constitutional Court has held, and starting with the Minister of Finance versus Van Heerden, that the Constitution recognizes the incontrovertible fact that we are all not equal in our country. If legislation and policies deny this reality, it will simply lead to an entrenchment of existing inequalities. And the court said that the jurisprudence of this court makes plain that the proper reach of the equality right must be determined by reference to our history and the underlying values of our Constitution. It goes beyond a mere formal equality and mere non-discrimination, which requires identical treatment, whatever the starting point or impact. So just to highlight that point on equality, we've had the courts have been reviewing legislation, often finding sections of it unconstitutional if it doesn't comply with the Equality Clause. And there've been a number of new laws as a result, often of those judgments, or proactively combating employment discrimination with the Employment Equity Act, the Civil Unions Act to legalize same-sex marriage and prevent discrimination on the basis of sexual orientation. So there have been many achievements, and as a nation, we've made real and very significant progress. Access to services have been broadened immensely, and I think this is no doubt due to the justiciable socioeconomic rights in our Constitution and various groundbreaking judgments handed down by our courts. Millions who were previously excluded now have access to education, water, electricity, healthcare, housing, and social security. And it's important to highlight that many, if not most, of the advances we've made in our country are because of the constitutionally guaranteed human rights. Active citizenry has also been important in ensuring access to those rights. So that's a sort of good side, but on the bad side, I mean, this is a webinar about the Constitution as the catalyst for the achievement of equality. And the problem is that, as we all know, we are one of the most inequitable countries in the world as far as between the haves and the have-nots. Earlier this week, the findings and data from the 2022 World Inequality Report were released. And it shows while the richest South Africans have wealth levels broadly comparable with those of affluent Western Europeans, the bottom 50% in South Africa own no wealth at all. The top 10% own close to 86% of the total wealth, and the share of the bottom 50% is in fact negative, meaning the group has more debts than assets. Since 1990, the average household wealth for the bottom 50% has remained under zero. Recently, Mark Hayward, civil society activist, in a Daily Maverick article wrote, on December the 10th, South Africa will celebrate the 25th anniversary of its constitution. Thanks mainly to civil society activists, it's still alive, but it is chronically ill. The failure to realize the rights promised to the poor on the grounds that we don't have enough money is rapidly undermining confidence in the Constitution and the rule of law. So when it comes to equality and our Constitution's guarantee of equality, why are we seeing such high levels of inequality? And if Mark Hayward is correct in saying that the Constitution is chronically ill, how do we fix it? What more can we do in practical terms to ensure that the Constitution is indeed a catalyst for the achievement of equality? And are some South Africans taking human rights for granted, for example, choosing not to vote? Are we embarking on tick box exercises where we say we're implementing and giving effect to the provisions of the Constitution, but in reality, the impact is not being felt on the ground? So these are some of the issues which we hope our very esteemed panel will be able to address and unpack further this morning. I would therefore like to call on Justice Albie Sachs, former Constitutional Court judge, the first Constitutional Court, and author of a number of groundbreaking judgments, a activist before that. I think, Judge Albie, if you can excuse me not going into further details, but you have a long and impressive CV, but over to you, Judge Albie. Also, just to the panelists, I've got a note here that everybody is meant to have 5 minutes. So if you can try and keep to that 5 minutes so that there is time for the question and answer session. Thank you very much. Over to you, Judge Albie.
Thank you, John. And, you know, this day, it brings me back to the time in exile. And every 10 years, the ANC would ask me, as a member of the Constitutional Committee, to write a paper on the Universal Declaration of Human Rights, how we see it as a South African. And I remember going through the Universal Declaration and showing that every single right mentioned in the UDHR was violated in apartheid South Africa, every single one. It was quite astonishing. Apartheid was so pervasive that there wasn't an aspect of human life that wasn't vitiated by it, except for one. The only one that I couldn't point a finger at was the right to intellectual property. I tried very hard. So I had to say 99% of the rights in the Universal Declaration of Human Rights were violated by apartheid South Africa. So that was 68, 78 repeating, 88 I was blown up, lost my arm, sight in one eye, 98 I'm on the court. And now we have one of the most progressive constitutions in the world. And the theme of equality is very pronounced in the Constitution. But how to apply it doctrinally, how to develop it. And the very first case where this cropped up full frontally was Prinsloo and van der Linde, that dealt with fires moving from one farm in a fire-protected zone to a non-fire protected zone. And there was an allegation of a lack of equality. And I was asked to write the judgment. And I felt this is not what equality law is about. Equality law is not about treating everybody alike in similar circumstances. Equality law is about people who suffered for being who they are. Black, female, Asian, gay, for being who they are treated in a discriminatory way. And our equality jurisprudence has to develop along those lines. So very early on, we decided we look at the impact of the laws. We look at systematic forms of exclusion and marginalization. We look not only at the intent of the laws and the practices, but the way they affect people in real life. And we try to secure fundamental respect for the dignity of everybody in a very diverse society. We were asked to go beyond simply dealing with human dignity as the core element, to use the equality provisions to get material equality, economic equality. And the feeling of the court was that was beyond the role of the Constitutional Court judges. That was the overwhelming project of Parliament. Social and economic rights mitigated the impact of material inequality, but basically our equality law was focusing on, if you like, the human soul, the indignities imposed upon people for being who they were. And as it turned out, there are two areas where our jurisprudence has become significant and is being cited throughout the world as path-breaking. The one is equality in terms of the right to be different, very much put to the fore in terms of, at that stage, the gay and lesbian community, in demanding the marginalization, the oppression, and the exclusion to which they were being subjected to because of their sexual orientation, that be removed. And the core to that approach was, you don't say to be treated equally, you've got to become like the mainstream. You have the right to be treated equally across difference. That's the unity in diversity theme. And the decisions of our court, our jurisprudence, and based on constitutional text, have been cited throughout the whole world, the right to be different in the context of equality. The second area where we've pioneered an approach is in relation to patriarchy. And that's been particularly important in the approach that the court developed in relation to customary law. When it came to the certification of the constitutional text, Contra Lesa and others argued very forcefully, very eloquently, that patriarchy was central to the nature of customary law. And so if we apply customary law, then the patriarchal principles must be embodied. And to the extent that the Constitution said the equality principle prevailed, the Bill of Rights prevailed, it was denying proper protection of customary law and upholding of customary law. We rejected that argument, and it meant then that customary law is a foundational source, original source of law equal to the common law in terms of its authority and importance, but like the common law is subject to the principles of the Constitution. And I think what we developed uniquely in South Africa was the notion of living customary law. That's a customary law that embodies the principles of equality between men and women. So we rejected the principle that boy children could inherit and girl children couldn't inherit. We said it was permissible for the Baloyi community to choose Mrs. Shilabana to be their traditional leader, although there was arguments against that in terms it was said in terms of customary law, only men could be traditional leaders. We rejected that, and we rejected that not because we thought we knew better, but we felt that that's what the community wanted. That was their choice. It's the choice of the royal family, of the community. Customary law, if it prevented women from becoming traditional leaders, was unconstitutional to that effect, to that extent. So these are progressive ways of developing true transformation in areas greatly significant to a huge number of people in our society. Women of half the population, poor rural women in particular, were very much at risk and very vulnerable if patriarchy continued to dominate their lives in terms of access to property, to land, to self-expression in a multiplicity of ways. So just to wrap up then, we haven't seen that the Constitution as such compels the judges to tell the executive and parliament what to do about bringing about more material equality. We say workers have to be protected in terms of their rights, to be protected in their dignity, fair labor practices, the right to strike. Women are protected, gender-based violence is expressly excluded, right to make decisions in terms of terminations of pregnancy, reproduction, expressly included. And all of this came from the fact, and I'll conclude with this, our Constitution was not the product of lawyers sitting in a smoke-filled or smoke-free room coming up with their ideas of what a beautiful Constitution would be. In that sense, it wasn't an elite product. It was produced in Parliament by the elected people from the nation with a mandate to bring about change. And overwhelmingly, I'd say more than half the people at the Constitutional Assembly, the 490 Parliament elected, had been in jail, in prison, in the resistance, in the underground. A very strong women's group was there with the support of the National Coalition of Women. There were strong trade union representatives. The workers had struggled hard for our democracy. They were well represented. So that's why we have a constitution with a wonderful text and a transformative text and a pro-people's text for the vulnerable, for the marginalized, for the excluded. And that's why to achieve the further advances in the material areas and other areas, the same struggles that led to the composition of the Constitutional Assembly and the debates and arguments that were ultimately triumphant in the CA, the same kinds of united actions of diverse people with a common goal set out in the Constitution will be required to make equality real in the lives of everybody in our country. Thank you.
Thanks very much, Judge Sachs, for that detail on some of the judgments from the Constitutional Court and also the constitution-making process. Our next speaker is then Mr. Sello Hatang, who is the Chief Executive Officer of the Nelson Mandela Foundation. Mr. Hatang, over to you.
Thank you very much, DM. Ntate Tipanyane, Minister, in your absence, DG, Justice Albie Sachs, Chair of the Human Rights Commission, Menoko, my friend Steve, Atehang Ramoji, Prof. Meyersfeld. Good morning, ladies and gentlemen. Thank you so much for this opportunity to speak to you on this very important day. After Justice Sachs, what does one say? Because one gets stuck in understanding how we got where we are now. After the ideals that the Constitution or the constitution-making process started off with, how did we get where we are, is the question. And I go back to the theme of the Constitution being the catalyst for change and for building a more equal society. And this serves as a reminder that we, as the people, are the Constitution. We are the Constitution. We should never forget that the Constitution remains what it is, which is a representation of ideals by people like Justice Sachs and others who thought it important to be a particular nation. But it rests on us as people to say we are the Constitution. If there is inequality, we have to take the blame. If there's no rule of law in our country, and we're beginning to turn it into a gangster state where young people cannot just walk the streets and feel free to just be or women cannot just feel free to walk on our streets, then we are to blame. The illness of the Constitution, as the Deputy Minister said earlier on, is a signal of the woundedness and a sick nation. If we point at the leaders, we must ask ourselves, where are we in that equation? Where are we as the people? Are we always waiting for a Messiah to come in and save us and show us that choices we make sometimes are choices we shouldn't be making for greater good that needs to come through? So choices we make also tell a story of our woundedness, our sickness as a nation. How do you explain that the Constitution gives us the power to elect leaders in the recent local government elections, and we choose a convicted rapist? We choose someone who, a fraudster, convicted fraudster in the Northern Cape. How do you explain that? That tells you that we are a wounded nation. We are a sick nation, and the Constitution is us. It shouldn't be that we then separated from who we are. We are scrambling because of the decisions that we've made in recent past. So if the Constitution were to become a lived reality for the great majority of our people living in this country, and a real catalyst for change, then amongst other things, we must ask ourselves why our education system is not empowering young people to thrive in the world. Why is foreign investment not flowing in order to grow the economy that we want? Why is the economy not vibrant, inclusive, and growing in liberatory ways? How come we are not reliable as a destination for people to just say, that's where I should go in terms of putting in their money? How do you explain that the N3 can be closed any other day? And yet we expect that the Constitution will deliver. The Constitution, I emphasize. And I say again, we are the Constitution. Democracy would be deepening, would be more equal, would be more united. Instead, we are more divided than maybe in most recent times that we can remember. How far are we from such a reality that Madiba dreamed of, that Judge Albie Sachs dreamed of? So constitutionalism should be the overarching framing or theme for the work that we need to be doing. Are we constitutional beings? We should ask ourselves. And by constitutional beings and by constitutionalism, we should mean the use of the Constitution or constitutional instruments to transform fundamentally a society shaped by centuries of oppression. Sadly, most often than not, the Constitution is used to protect power, privilege, and property. It must be reimagined as the means for distributing power, privilege, and property. But how does this vision translate in practice? In the context of South Africa today, where, if we are brutally honest, democracy is not delivering, where inequality has reached obscene levels, as everybody has said before me, where survival has become a reasonable measure of success. What could be done differently at a time like this? What should look like, what does a practice look like, as opposed to theorizing? So as I close, I urge all of us, those who are on the panel and those who are watching this, the webinar this morning, we must commit ourselves to say, we want to do differently. We want to ensure that those who gave us the power to bring about change in the lives of many, that we do bring about that power. And that everything that we do is part of an ecosystem that ensures that we become a healed nation, a nation that does not then blame the Constitution as a sick instrument, but rather say, maybe we are the sick ones, and how do we ensure that we do differently? It's in our hands to build that country, to give hope where there's hopelessness, and to keep reminding ourselves, we are the Constitution. It will never move an inch until we move to make it different. Thank you very much.
Thanks very much, Sello. I think that's a very important point that you've made, that we are the Constitution. It's the people of South Africa who are the Constitution, and we all need to play our role in ensuring that the ideals of the Constitution are lived up and we have the type of society we want, rather than trying to find always other people to blame. The next speaker is Ms. Steve Letsike, who is down on the program as being from Access Chapter 2, which is an organization working in the LGBTQI sector and also with women's rights. But also, Steve is also the co-chair of government, or the Department of Justice's National Task Team on LGBTI people. And she is also the co-chair or the deputy chair. I'm not sure which, Steve, I was confused at our last meeting in Durban. But the co-chair or the deputy chair of the South African National AIDS Council. But over to you, Steve.
Thank you so much, Deputy Minister, Honorable Jeffrey. Let me also appreciate, the overall program director, CEO of the South African Human Rights Commission, Advocate Tipani, in his absentia, Minister of Justice and Correctional Services, Honorable Lamola, Director General of the Department of Justice, Advocate Mashabani, Chairperson of the South African Human Rights Commission, Advocate Majola, the Regional Representative of the Office of the High Commission for Human Rights, Ms. Noko, to my fellow panelists, of course, former Constitutional Justice, Albie Sachs, my friend and comrade, CEO of Nelson Mandela Foundation, Mr. Hatang, representative from the academic field, Prof. Meyersfeld, and of course the youth representative from the Val Heritage Activist Foundation, Ms. Ramoji. Fellow delegates, participants, friends, siblings joining us from various platforms, a very good morning to you all. DM, it is a great honor and privilege to be joining this session. It is a most important event that brings all of us together, and we join the rest of the world in marking, first we mark the 73 years of the anniversary of the Universal Declaration of Human Rights, but most importantly, it's also marking our own important 25th year of South Africa's Constitution signing into law. I consider this day, 10th of December, an historic moment in our lifetime in the quest for human rights, for freedoms, for dignity and integrity. Today we speak and we reflect on the history of both the tragedies and triumphs we have had as South Africa, but also the rest of the world. And both the Universal Declaration of Human Rights and the Constitution were adopted at times where nations were deep-rooted in scars of war, and when South Africa were also in the pathway of repairing the injustice of the past. Our history of South Africa shaped us and continued to shape us, but we do have a long history of colonialism, of prejudice, criminalization, stigma, and discrimination that continued to divide us. We both, while both these documents gave hope and became a beacon of hope to set up a vision of unity, of respect for all, of valuing the rule of law that guides arms of states and its citizens to protect, promote, and fulfill the human rights for all. It is fundamental, DM, to the cause of human rights that we protect equality and we promote equality for all people from discrimination and violence. And it should be obvious that there are many different ways to be human beings. We need to respect and embrace these differences, not criminalize them, not attack people, not deprive people of their equal rights or protection of law just because of how they are seen as different. The struggle for rights of LGBTI people is a core part of the human rights struggle, as the panelists have indicated. And yet in many parts, here in South Africa and also in the world, members of the LGBTI people continue to be targets of brutal attacks, brutal murders, and discrimination and victimization, and of which, to some extent, many are left unpunished. It is also essential that we defend and protect the LGBTI people from any kind of violence and discrimination. There shouldn't be anything or nothing controversial about stopping people being murdered or executed by agents of hate. And I call them agents of hate because it is regarded hate crimes, simply because of who people love. Tackling extreme violence does not require any new norm, so it's not a new thing. It should not become any controversial. Let us reflect a little bit in the streets of our communities in South Africa, but also in Africa. For far too many painful years, there has been muteness, a vast muteness and silence and quietness about African daughters and sons, African men and women, African gender non-conforming person in all their diversity, who self-determine, observe their bodily integrity, who yearn to love and who also embrace their partners. And this muteness have denied recognition, denied reality, the truth, and throughout the history of LGBTI people have been predominant here as in anywhere else in the world. And this muteness and silence has created injustice, for it was born from control, fear, and from disrespect of humanity. And again, both Universal Declaration of Human Rights and South African Constitution proclaim that everyone without distinction has the right to life, liberty, and security of persons. Where there's been patterns of hate-motivated acts and violence, one, for an example, based on gender, sexual orientation, and gender identity. And also where the state does not act to prevent or effectively address those attacks, it is failing to live up to the obligation. And I think it is some of the examples that we have to reflect on and as we seek to speak about equality. While we seek a catalyst approach ourselves, we have to reflect on what has happened just this year, 2021, where LGBTI people have experienced a horrific brutality, with over 21 LGBTI people here in South Africa murdered, brutally murdered, over 30 cases of reported physical and sexual assault. And it is important to also note, while we talk about numbers and stats, Love Not Hate campaign partners reported in 2016 that 88% of LGBTI people do not report any incident that happened against them. And it is telling us 1 out of 25, only 1 gets to report. So the numbers that I've reflected on, you would then realize why we are where we are. But the worst still, when the victims of attack seek protection, they are frequently subjected to intimidation, secondary victimization, abuse, including this from police or officials. We also know that violence is not only the issue that is troubling the LGBTI people. The other issues that troubles LGBTI people include disowned by families, denied and expelled from school or work, rejected by churches, denied affirmative social services that includes health, safety, justice, or even education. And it is imperative to realize that it has to do with discrimination and victimization. And to some extent, it also includes the loss of work or job opportunities for that matter. While we acknowledge that there is a complex anxiety at play in the way...
Sorry, can you start winding up?
Yep,
can you start winding up? You've gone over.
I'm counting my time. Thank you, DM. We have to acknowledge as well some of the challenge that we are reflecting to. The challenge also of in Africa and globally as well. 71 countries across the world, of which 31 are in Africa, still criminalize homosexual acts. The result is impunity. Too many victims goes without recognition, remedy, or justice, and too many perpetrators are free to strike again undeterred by the prospect of the rule of law. And I think South Africa has demonstrated leadership with the Constitution and the constitutional development. The entity that was established became the beacon of hope, where we are now in the third generation of the national intervention strategy, where we track cases, where we track progress of justice. And I'm hoping that government will also still put enough investment to ensure that prevention measures are in place. South Africa's progressive laws have demonstrated through upholding the human rights, but these strong national trends, which are regarded global trends, must ensure access and equality for all. Now, while I end, Deputy Minister, I want to recognize that many organizations and many LGBTI people have been doing so much to open the people's heart and mind, which is change behavior efforts through continued campaigns, but we also need further education of these rights to people for respecting diversity, including diversity of LGBTI person. Now, two laws that must be quietly thought through. Hate crimes law must be in place. Hate crimes and hate speech law must be in place, and South Africa must fast track that process. But I also call on the South African Parliament and government to ban conversion therapy and practices. Research that has now been concluded, 58% of LGBTI people have experienced conversion practices in South Africa, and of which 47% have experienced conversion practice under the age of 18. And it is something that we need to think through, ban conversion practices. So we need leadership, we need continued religious leaders, traditional leaders, to play a positive role in this change. I believe that profound positive change is possible. I've seen it in my own lifetime. It can be done by all. We need allyship in this effort. Thank you so much, Deputy Minister.
Thanks, Steve. We are unfortunately now running a little bit behind schedule, so let me move straight on. The next speaker is Atlahang Ramoji. Atlahang is a youth representative from Sedibeng and was nominated by the Vaal Heritage Activists Foundation. So Atlahang, over to you. Please, if you can, stick to the 5 minutes. Thank you.
Thank you, sir. Greetings to the President of the Republic of South Africa, President Cyril Ramaphosa, Ntate Ronald Lamola, and other ministers and deputy ministers here and present. Representatives of the United Nations agency present here, all the executive mayors and all the councillors also present. Speaker of Sedibeng Municipality, Councillor Memwi Poni Mudikeng, and speakers from local municipalities of Mfuleni, Midvaal, and Lesedi, councillors, leaders in business chambers, corporates, and entrepreneurs, labor organizations here and represented, as well as leaders in state enterprises and in government administrations. Bommelebon Tateva Kulumani Support Group, representing families of victims and survivors of brutally of what happened, of what apartheid had left as a legacy in our beautiful country in 1994. My deepest gratitude goes to leadership of Vaal Heritage Activists Foundation for this huge opportunity to address the occasion to mark the 25th anniversary of the signing of the Constitution of the Republic of South Africa in Sharpeville by former President Nelson Mandela. President Ramaphosa and his administration, thank you for choosing to come back here in this area of the Vaal. Literature I read and conversations I have with my parents, my teachers, my uncles and grandparents told me that the primary reason Sharpeville was chosen for that historic occasion in 1996 was because 1960 Sharpeville massacre epitomized gross human rights violation, injustice, brutality, and criminality of apartheid state. In the words of former President Nelson Mandela at the ceremony of the signing of this constitution here in Vaal on the 10th of December 1996, he quotes, out of many sharpfalls which haunt our history was born an unshakable determination that respect human life, liberty, and well-being, which must be enriched as rights beyond the power of many forces to diminish, in closing quote. 25 years of exercising rights guaranteed and enriched our constitution. We are on a cusp of losing hope in a democratic project and the dreams it represents, as well as the society and you and your generation have committed to build since 1994. Over the last 25 years, a democratic government worked hard to restore dignity of many people, providing free education, increased access to higher educational skills and development opportunities. People benefited from free housing, electricity, water, libraries in townships, and etc. This constitution shall remain shallow and meaningless if we are not going to pause and reflect on its meaning, impact, and its intent. We must work together as government, industries, and ordinary people in non-governmental organizations to put dreams of Ntatemoholo Mandela, yourself, President, back on track when this constitution was finally adopted many years ago. It is a great legacy in your generation can bequeath to us as the present generation and future generations to internalize, embrace, and live its provisions as we continue in a journey to create a country in which we all and equally belong in it, black and white. It must represent a heritage in which generations after generations will celebrate not only its existence, but its ability to qualitatively and quantitatively use to effect change, transformation, build a united, non-racial, non-sexist, democratic, and prosperous country. This important day on the 10th of December, it coincides with an equally important moment in global politics, since it also marks United Nations General Assembly having adopted the Universal Declaration of Human Rights in 1948. The theme adopted by our government for this year, the Constitution as catalyst for achievement of equality, and the UN theme, equality is the solution to provide opportunities within and access to a further and fairer and more inclusive society. These themes galvanize everyone in our country and to the world to stand up for human rights as we review and reflect on our country's lived experience of constitutionalism, working to strengthen the constitutional values of human dignity, the achievement of equality and advancement in human rights, freedom, non-racialism, and non-sexism. From my eyes, what do I see since our constitution was signed into law? The reality on the ground 25 years later is that racism, intolerance, prejudice continue to live and breathe among our people. A gap between rich and poor is growing every day. Gender disparity, including pay gap in the workplaces between men and women, still alive in many private and public institutions, corporates. I see prevalence of xenophobic tendencies, breeding of fear, violence, and destruction of property under the guise of service delivery, which continue to flare up every day in communities. Scourge of violence against women and children, femicide and gender-based violence has reached a scale of pandemic of a special type in South Africa and must be defeated. Queer communities are targeted and exposed to to dangers based on gender identity and sexual orientation. It is for this reason that the 25th anniversary of the signing of the Constitution of the Republic of South Africa becomes an important moment to take stock, reflect, assess, and review various intervention in judicial and constitutional means to migrate as well as to live expectations promised by the Constitution itself. It means an ongoing process, an ongoing work of building a truly united and diversity nation will not happen on its own, but demands more practical and sustained programs on the ground. People must be able to access services, institutions, resources, advice, and the means to enforce their rights and strive for equality as promised by the Constitution. Happy 25th anniversary of our beloved Constitution. We shall never abandon this legacy project bequeathed to us by a generation of brave men and women who fought for freedom, because in every country where the Constitution and rule of law fail, women and children, most vulnerable, are the primary victims. Not in our name, not in our lifetime. Constitutionalism forever. I thank you.
Thanks very much, Atlahang. Without further ado, if we can then call on our last panelist, Professor Benita Meyer.
We're coming out of that commemoration of 25 years of the democratic constitution in South Africa. We'll make sure to go back in a bit, but onto the story now. The trial against former Minister of Social Development, Bathabile Dlamini, currently underway in Johannesburg. We'll also take you to that story. Let's take a quick break. All right, onto the story now. All right, let's take a break. We'll be back in a moment.
Sure that citizens, but as well as the law enforcers, are at par excellence of competence and application of delivering justice, delivering ethical and also interdepartmental approach to applying the rule of law. We miss out in that. And the essence that we are challenged with here, it's also of the behavior of South Africans. I think we have taken lightly the Constitution, and we are actually seeing more and more South Africans who likely are squandering this Constitution. We cannot afford to really squander this Constitution. And I think every point that has been raised also relies about us and our responsibility towards this very same rule of law, but as well as the arms of states in applying the protective and the promotion and fulfillment measures in place. So at one stage, we have to just put our finger in it and surely deliver the just approach in a timely. We can't delay justice. We can't accept inequality. We cannot also look when things happen in front of us and we do nothing about it. So our responsibility to make sure that some of the legislative pieces that are missing, including such as decriminalization of sex work, as well as hate crimes, are key and are equitable for all. For us, it's an application. Thanks, dear.
Thanks very much. Then to Mr. Hatang. Sello, you're muted. You're muted.
Apologies. I was thinking, what do you say in 3 minutes? And I thought maybe we need to then be talking about the next 25 years. How does that picture look like? And I'd like to put a few thoughts across in terms of that next leg of the 25 years. I think the first one is to ensure that we give youth a greater voice. Atlahang this morning demonstrated again why we need to keep giving young people a voice so that they can then keep pushing boundaries and that they let us feel that we are pushed. The second one is building a more accountable state. But I use not just government, but state, we as the people, that we must be accountable, that we must hold each other accountable. The third one is the protection of whistleblowers. If we are to break the back of corruption and other problems that are in our society, we have to do that. The next one is building a more inclusive society. And on this point, it's important that we kind of reflect on how this inclusive society should not just be something that we speak of, but actually we keep trying to achieve, because it is possible to build such an. The next one is about the issue that Steve just raised on the rule of law. I think if there is law, we just have to make sure that we become constitutional beings who then ensure that we build that culture of the rule of law. Rebuilding state institutions that were broken by or crippled by state capture can help with that kind of system of rebuilding, of bringing back the rule of law. I want to close off with just a thought that dreaming, the Constitution is about a dream, but dreaming is not enough. That it's time that we then ensure that we don't just hope for what's possible, that we have to work hard for that society that we dream of. We have to ensure that we lift early childhood development from where it is to where it should be, that we ensure that our education is the one that empowers our children, not just to focus on matric, but ensure that we start right there in the root. So I want to end off there and say that each one of us carries that responsibility to build that society that we dream of. Thank you.
Thanks very much. Actually, people were a lot better behaved than they were originally. So Judge Sachs, you can have a little bit more time, which I think is also, you are a institution. So I think that's important. Let me just also raise a point that maybe you can also respond to. I'm getting criticized for not talking about an anti-vaxxer input, who says the religion of COVID-19 led by the World Health Organization and imposed on us through those we elected as leaders is threatening the very core of the Constitution, the Bill of Rights. Our rights to bodily integrity as enshrined in the Constitution is being eroded by imminent mandatory vaccinations, which will constructively force people to take part in ineffective and unsafe medical experiments, in brackets, gene therapy vaccines. The vaccines have killed and injured many, and our government is hiding this genocidal potential. And is there a document is the Constitution a document for the powerful and a curse to the powerless masses? Obviously, you can, Judge Sachs, you could respond on that. I mean, really just to say that, I'm not sure how this government can hide information. The internet information is freely available. I am not a doctor, but, anyway. I have raised the point, Judge Sachs, and ultimately the issue as to whether it's constitutional, unconstitutional to say if you don't get vaccinated, you can't do certain things. It's going to be up to the Constitutional Court to decide which is what it should be. But Judge Sachs, if you could wrap up, you have a little bit longer, maybe 7 minutes or so, or 7-10 minutes.
Okay, I won't hold it against you, John, that you refuse to call me Judge Albie, but I'm speaking now not as Justice Sachs. The courts will deal with the vax matter. So I'm now speaking as Albie, and let me get that out of the way. I too have a right to my bodily integrity, and I have a right not to be invaded by the virus, if I'm going about my work in the ordinary way, from people who refuse to be vaccinated, who become, in that sense, potentially lethal agents of invading the bodily integrity of others. And the question really is balancing out the claims of individuals who don't want to be vaccinated. They might put it on all sorts of different bases and grounds, that's their right to do so, but who refuse to acknowledge that by so doing, they're endangering the bodily integrity of others. And there it always becomes questions of limitations and what's appropriate. We take vaccinations for measles, for mumps. Our kids get vaccinated. That's been happening all the time. Now there seem to be major campaigns, sometimes given a political slant, to get people to refuse, not to hesitate, to refuse to take the vaccination, which is a public health matter. So it's an issue that will go before the courts. Private companies can make their decisions. Discovery now has found a huge uptake of people, 94%, I think, have agreed to be vaccinated. Whether access to public places and spaces, whether the right to work can be jeopardized, often these things can be balanced out. And so if somebody has a true religious objection, then if they can prove through taking the tests that they are not carriers of the virus, maybe an exemption can be created for them. But I don't want to go too deeply into that. The justices will deal with the issue. Safe to say that I feel the allegation made by the person sending in that question is completely misfounded. It's not based on science, it's not based on reality, and the people who will suffer the most will be the unvaccinated, who tend to come from the poorer sections of the community. They will suffer the most from the approach that's being adopted there. The two issues that I'd like to deal with are corruption and is the judiciary protecting the powerful? Let me start with corruption. There were two themes that turned out to be very important in South Africa that we didn't really envisage when drafting the Constitution, and we didn't create special provisions in the Constitution to deal with them. The one was HIV, and the impact of the pandemic was enormous. It was really threatening to destroy South Africa. There was a sense of helplessness, hopelessness, not aided by a denialism on parts of those in authority. And the specific theme of discrimination on grounds of HIV was not included in medical status in the list of prohibited areas of discrimination. But without difficulty, the Constitutional Court said, in the case of Mr. Hoffman, who wanted to be a steward on the South African Airways, was told you can work on the ground selling tickets, but not pouring coffee because you're HIV positive. And we said that is unfair discrimination. It didn't slot in, obviously, in terms of any of the categories mentioned in Section 9, but it was such a grievous invasion of his right to work, of using ill health. You don't say people can't serve coffee because they have cancer. This was based on prejudice, and we declared that to be unconstitutional. But more significantly, in the Treatment Action Campaign case, the court ordered that the government was obliged to make antiretrovirals available to women about to give birth, women living with HIV. And that saved South Africa. If there was, Constitution did nothing else in 25 years, that decision of the court, which arose from people on the ground mobilizing, tens and scores, maybe hundreds of thousands of people living with HIV mobilizing to claim their rights. it came because journalists picked up the issue, civil society was strong on the issue, and it came because we have legal bodies willing to craft a clearly focused case based on the Constitution, and the Constitutional Court unanimously deciding that antiretrovirals had to be made available. So this is an example of the court not protecting the powerful, right to the top of government, but protecting the people on the ground. And that's been the role, certainly the 15 years that I was on the court, that I felt I and my colleagues all felt totally committed to. So when it came to corruption, corruption was not mentioned in any of the themes in the Bill of Rights, and there were no institutions to protect democracy solidified around people having a special role to deal with corruption. So we have the public protector, deals generally with conduct in the administration. We have the Auditor General, especially protecting the books of all the agencies of government. We have the Commission for Gender Equality dealing with that issue. We don't have a commission or a body in the Constitution dealing with corruption. And maybe looking back now, it was not a failure on our part, but something that maybe should be considered for an amendment, a constitutional amendment, to create a body with the same independence that the other Chapter 9 institutions have, devoted to dealing with corruption, protecting whistleblowers, ensuring that their prosecutions, creating information and understanding, and independent of the agencies that might themselves be corrupt, not subject to their control. And I think that's something that's emerged that this 25th anniversary, we should seriously think about, hopefully to get cross-party support for a body of that kind. Even the people who are in positions of authority or in parliament, whatever party they might belong to, who might have fingers being pointed at them, hopefully they will at least support the principle of an organization, institution of that kind. What the judges did in cases dealing with the dismantling of the Scorpions, the majority of the Constitutional Court judges said, even although corruption is not mentioned expressly in the Bill of Rights in any way, and there's no Chapter 9 institution dealing with it, corruption threatens the achievement of all the other rights. It undermines it. It allows people in power who should be upholding fundamental rights themselves to take kickbacks, to have interests outside. It's not just the deviation of money, it's the destruction of virtue, integrity, and honesty, destroying the trust of the people in the agencies of government. And so they said the need for having an independent investigative body investigating and prosecuting is a constitutional requirement. So in that sense, the judges, in a creative way, consistent with all the values of the Constitution, to protect the poor and the vulnerable, not the powerful, the judges said we do need to have, and that's how the Hawks came into being, and that's provided the basis for now helping to transform and strengthen and invigorate the prosecuting authorities happened. The last question I want to deal with is the allegation made that the judiciary, particularly the Constitutional Court, is there to protect, is violating the Constitution itself. And I'm thinking, what's behind that allegation? It came through to me so strongly at the time of the insurrection, or the, whatever you call it, the looting. And people were speaking about the tension without trial. Now, I feel so strongly about the tension without trial I was detained without trial. I belong to that generation detained without trial. I was the one that early on in negotiations saying detention without trial must be prohibited expressly in our constitution, because that was the foundation of the tortures, the violations, the destruction of our whole criminal justice system, putting the security police in effect in a much more powerful position than any judiciary, any judges. And detention without trial meant we could be picked up, thrown into jail, kept in solitary confinement for 90 days, and another 90 days, and another 90 days, eventually without limit, that we could be tortured and beaten up, brought as witnesses. If we didn't say what the security police sitting in court wanted us to say, they would bring others and others and more and more and more. It was something gruesome and horrible. And to say that the decision of the Constitutional Court to make the order that it did in relation to former president, for clear defiance of the court order, involved detention without trial, that's alleged to have been a form of protecting the powerful. For me, it's exactly the opposite. It's avoiding impunity. I don't want to get into the merits of the case, and I don't want to say anything about the former president, who we were comrades together for 10 years in Mozambique. We stood at the gravesides of people who'd been murdered, and we sang freedom songs. I have nothing but emotion remembering those days of ourselves together in the struggle. But time has moved on. People have made their decisions. They have to take the consequence of their decisions. But what I felt at the time of the looting was, I'm so glad we're not using the methods against insurrection that we in the freedom struggle were trying to promote to overthrow apartheid with all forms of resistance. We're not using the methods the apartheid regime used at that stage. We don't throw people into jail. We don't have an all-powerful secret police. We don't have people being picked up at dawn and disappearing. We don't have the assassinations. And I'm glad we don't have those things, even if it takes longer. The rule of law exacts a price. It exacts a price. You have to follow proper procedures. It takes longer. It requires proper evidence. It allows for defense and cross-examination in ways that were not permissible before. It allows for rights to information, to look at dockets, to much more fair trial than was ever possible in the apartheid days. And so for me, maintaining the rule of law is fundamental for the rights of the poor, the marginalized, the dispossessed, the neglected in our society, more than of the wealthy. The wealthy don't need the rule of law. They've got money, they've got power, they've got connections. They can move off to another country if they're unhappy with the way things are going. It's the poor who can't move. It's the poor who most need the Constitution, most need their rights, who require the rule of law, are dependent upon the judges being independent, doing their duty, and not being bothered by allegations and charges made against them that many people believe, many people believe, are designed to defend crooks, to defend those who are malicious with regard to the application of the Constitution to ensure equality for all. Equality for all means however high you are, however low you might be in society, you have to be subjected to the processes under the Constitution. You have to be accountable for what you do. If you've misbehaved, if you've been corrupt, if you've done things that are impermissible under the law, you have to stand trial. You have to take the consequences. If you're asked to present yourself to commissions of inquiry like everybody else, you're not in a position to say, somehow I'm exempt from that. Now, this is Albie speaking. It's not Justice Sachs speaking. The courts will speak for themselves.
Judge Albie Sachs there, his contribution to the 25 years of the Constitution of South Africa